Right. The legal system in countries around the world generally fall into two main categories, the common law system and the civil law system. What is the main difference between the two systems and what are the roles of the lawyers and judges in each system? The part B of this question is how the provisions of international conventions are getting effect in countries following the above systems of law. State and describe the example. So this question is divided into two parts, 8 marks each. One is regarding the legal systems in countries around the world, and the second part is how the provisions of the international conventions are given effect in the countries following the above system of law. Now, the coming to the part one of the question, the difference between the common law and the civil law systems and roles of lawyers and judges. So the main difference comes with the common law system based on the precedents, case law. The decisions made by the higher courts bind lower courts. And second one is developed primarily in UK, US, Canada, and other former British colonies. Civil law system based on codified statutes and laws, comprehensive legal codes, originated in the continental Europe, parts of Africa. Roles of lawyers and judges. Now, a lawyer in a common law system and the civil law system. In a common law system has a adversarial role, prepares arguments, examines witnesses, controls much of the litigation strategy. In the civil law system, more investigator and consultative, assist in complying evidence and advising clients, less courtroom control, more documentation focused. Judge acts as a neutral arbiter in a trial, ensures due processes and applies precedents. In case of civil law system, plays an active role in investigating the case, guides the case, applies codified law strictly, interprets statutes based on the past ruling, and in civil law system, rarely creates law through decisions. Now coming to the part 2 of the question, application of international convention in common law and civil law countries. Okay, key concept, how international conventions, treaties and agreements are implemented domestically depends on the country's legal system and constitutional process. The common law countries follow the dualist approach. International law and domestic law are separate. International conventions must be enacted through local legislation before having a legal effect. Example, in United Kingdom, though it signs treaties, they are not enforceable in domestic court unless passed into law. Civil law countries, often following the monoist approach, the international treaties automatically become part of domestic law once ratified, without requiring separate legislation, if not contrary to the existing law. France ratified a treaty can be directly invoked in domestic courts. Okay, and the last, the summary table, the legal system approach, implementation and international conventions examples. Civil law is a monoist, automatically incorporated upon ratification. If it's monoist, it's directly incorporated upon ratification, like what happens in France. In dualist approach, common law requires enabling legislation. So you need to have a legislation like the UK Human Rights Act 1998.